If a party breaches a contract and the injured party has to pay extra to get a replacement contract, the breaching party may have to cover that additional expense as damages for its breach. But if the replacement contract is for higher quality work, must a breaching party pay for all the increased costs? The District of Columbia Court of Appeals answered this question in Thorne versus White. White needed a roof repaired. White initially contracted with Thorne to cover White's existing roof with new 4-ply roofing material. The contract price for this work was $225. Thorne brought materials to the house and began work. However, bad weather forced Thorne to stop. Thorne never completed the roof work. White then contracted with Koons Roofing Company to repair the roof for approximately $580. This new price was more than double the price in Thorne's contract. However, Koons replaced the entire roof, and Thorne had intended only to cover the existing roof. Koons also used 5-ply roofing material instead of the 4-ply material promised by Thorne. White sued Thorne for breaching the original contract, claiming that Thorne had walked off the job. White argued that the roof should have been repaired for Thorne's $225 price and sought damages for the extra money that White had spent to have Koons repair the roof. Thorne denied walking off the job, claiming that White had asked him to stop working. Thorne also claimed that Koons's contract price was higher because it included additional items that weren't part of Thorne's simpler contract. Thorne argued that even if he had breached the contract, he wasn't required to pay for the upgrades in the new contract. After a bench trial, the trial court found that Thorne had breached the roof repair contract with White. The trial court also found that the two repair contracts were substantially similar and that Thorne was responsible for all the extra costs White had incurred by having Koons provide the promised repair work. Accordingly, the trial court awarded White the price difference between the two contracts, which was approximately $355. Thorne appealed to the District of Columbia Court of Appeals.